Hi, in this video we will discuss the last part of the obligation and contract series. We're going to talk about the form, reformation, and types of defective contracts. Let's begin. If you've seen this part for the first time, I've already made 3 videos on obligations of contracts. This is video 1, this is video 2, and this is video 3. This is the last part of the obligations and contract series. Remember, in this series of videos, I'm not here to replace your college professor or your law professor, but these are only guides to help you in your study for recitation and maybe exams with regards to obligations and contracts. This also may be applicable if you have a contract and you may have a certain question, and I may answer them in this video. Let's begin. As a backgrounder, remember, a contract is a meeting of minds between 2 or more people where one obligates, undertakes, promises to another or to the others to deliver something, to give something, or to do something, even not to do something. Now, we will discuss how the form of the contracts. As to form of contracts, there are basically 3 types. There's the informal, there's the formal, and there's the real. Now, what is informal contracts? Informal contracts are those that doesn't require a specific form. It can be written, it can be verbal, as long as the contract has the 3 requisites of consent, object, and cause. Now on to the second important form of contracts. This is called the formal contract. Formal contracts are those which the law requires to be in a certain form, more specifically written, meaning some contracts have to be on paper and written in a certain way. Examples of the formal contracts are those that involve the sale of land through an agent, donation of property, contracts of partnership, contracts with regard to the creation of corporations such as the articles of incorporation or the bylaws. The last form of contracts are called real contracts. These involve interests in real property or property that's considered immovable. Now that I've given the 3 types of form, when is form important? Form is important for its validity, its convenience, and lastly for its enforceability, meaning if a contract does not follow a certain form, it can't be forced on the other party. Now, going back to the requirement that the law must be a certain form, remember, as long as the 3 requisites are there in the contract, the consent, the object, and the cause, the contract itself is valid and binding between the parties. It then may be not recognized by third parties or that it is unenforceable. It's still valid, but technically it can't be enforced on the other party. Now, there's a specific provision in the Civil Code which requires that contracts must be in a public document. What does that mean? It means that the contract or agreement must be notarized. What makes it public? Because the contract then is subscribed to or presented in front of a notary public, and a notary public signifies that these parties or these people who are parties to the contract have agreed to perform whatever is in the contract in front of the notary public. That's why the words subscribed and sworn to before me, the notary public. It makes the contract more binding, and specifically if the contract goes into court or there's a dispute between the parties and they go to court, the contract then, if it's a notarized document, does not have to be authenticated, or at the very least, as long as it's shown that it's properly notarized, then the rules of evidence would say that it is already sufficient to be authenticated, or meaning it does not have to be proven or presented by one of the parties to prove that it is a real or existing contract. Here is a certain graphic on what laws require the contract be in a public instrument. Number 1, contracts which object is the creation or transmission or reformation of real rights over immovables. Number 2, the cession, repudiation, or renunciation of hereditary rights or those involving conjugal partnership of gains. Number 3, the power to administer property for another. Number 4, the cession of action of rights proceeding from an act that appears in a public instrument. And number 5, all other documents which involve an amount in excess of 500 pesos. Now, here is the kicker on these documents that require them to be in a public instrument or notarized at the very least. The law will say that these documents or these agreements must be notarized or a public document. But if a contract or agreement is not notarized and it requires them to be notarized, it doesn't make them invalid. It just makes them unenforceable, and if ever they be brought to court, they have to be proven to be authentic. Again, the contracts are valid on its face, but not necessarily enforceable in court. The second segment of this last video on contracts is the part of reformation of contracts. Sometimes a contract is written without showing the true intention of the parties. The law allows that the contract be reformed or redone or rewritten with certain requirements or certain conditions that have to be present. Let me illustrate. Reformation of contracts is a remedy to conform the real intention of the parties due to a mistake, fraud, inequitable conduct, or accident. Here is the following grounds where reformation of the contracts may be ensued or may be performed. They are: the cause to reform the contract must be mutual, meaning it includes something which should not be there or should be omitted. The cause must be unilateral, meaning one party was mistaken in the contract, and the party in good faith will ask or may ask for reformation. Also, another cause is the mistake by third persons. Maybe between two people who make the contract, a third person wrote the contract and there was some lack of skill or negligence or bad faith on the drafter. And lastly, others specified by law, which is to avoid frustration or the true intent of the parties. Here then are the requisites for an action to reform or a demand to reform the contract. They are: it must be a written instrument. Of course, there's a meeting of the minds. There's the true intention of the parties is not expressed in the instrument. There must be clear and convincing proof, and if ever it goes to court, the facts put in issue. Now remember, the action or the lawsuit to reform the contracts prescribed within 10 years from the first execution of the contract. Of course, that is the general rule. What are the exceptions, meaning there is no option to have the contract reformed? They are a simple donation inter vivos, wills, when the real agreement is void, and when there is estoppel, which means the other party cannot anymore enforce it or cannot go back on his word with regards to the instrument or the contract. Now, let's talk about the kinds of defective contracts. The order of which I'm going to explain the defective contract is in the order of their validity. In the first part, they are valid contracts, and in the last part, these contracts are technically void or considered non-existent. The first type of defective contract is what they call rescissible contract, meaning one of the parties may terminate or end the contract based on certain conditions. These are the conditions for rescissible contracts to occur. Rescissible contracts are those which have caused a particular economic damage to either one of the parties or to a third person, which may be set aside if valid. It may be set aside in whole or in part and to the extent of the damaged cause. Now, there are specific grounds on what are considered rescissible. There are too many for this video, but I'll give you the other requisites for an action to rescind or have the contract rescinded. Aside from the grounds listed by law, the one asking to rescind the contract has no other remedy available to him, meaning he cannot anymore ask. He has to go to court to have the contract rescinded. Of course, if one who's trying to rescind the contract has received anything as part of the contract or part of the agreement, he must return what he has received. Remember, no one can get unjustly enriched. The third requisite is that no third party will be affected by the rescission. And lastly, it must be done within the prescribed period to rescind the contract, usually 10 years from the execution of the agreement. The second type of defective contracts is what they call contracts that are voidable, meaning these agreements or these contracts have an intrinsic defect, but they are valid until annulled, meaning if the contract's there, if no one complains about it, no one tries to rescind it or annul it, the contract will be valid between the parties. For a contract to be considered voidable, one of the requisites have to be either missing or flawed. Now, with regards to consent, some contracts may be entered into a party who cannot give consent, or maybe the consent is vitiated or there's a major flaw in the consent with regards to either mistake, violence, or intimidation. Also, some contracts that are voidable are those that have flawed or void objects or cause. The next type of defective contracts are those considered or called unenforceable contracts. What are unenforceable contracts? Again, compared to the voidable contracts are valid until annulled. In unenforceable contracts, they are valid on its face, but the parties cannot compel the other to perform the contract. There must be a ratification of the flaw of the unenforceable contract for the contract to be binding, or when the other party can compel the other to perform what is obligated in the agreement. Now, going back to ratification. Ratification is when one of the parties, knowing the flaw of the contract, knowing that it's unenforceable, agrees on the flaw and still continues or performs part of the obligations. So an unenforceable contract may be ratified either by, again, ratification or acknowledgement of certain parts of the contract. The last defective type of contract are those considered void or non-existent. Here are the grounds or requirements to consider a contract is either void or non-existent. Here are the requisites or characteristics of contracts that are considered void. They are: void contracts produce no effect whatsoever against or in favor of anyone. There is no action for annulment in a void contract. It cannot be confirmed, ratified, or even cured. It is imprescriptible, meaning a void contract is void forever. The general rule is that there are three types of void contracts. The first type is those that lack one of the essential requisites of the contract, meaning there's no consent, there's no object, and there is no cause. All three must be present for a contract to be valid. If one is missing, it can be considered a void contract. The second type of void contract are those considered by law to be void on itself. And the last type of defective contract are those considered illicit, meaning the cause or the object is not necessarily illegal, but against public morals, public order, morality, good customs, and public policy. I hope you picked up something in this video. Please explore my channel for my other videos. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.